Doctrine of conclusiveness of administrative findings of fact is not absolute. The doctrine of conclusiveness of administrative findings states that the Ombudsman's factual findings are usually conclusive when supported by substantial evidence, given their special knowledge and expertise over matters within their jurisdiction. Despite this rule, the Court of Appeals (CA) can review and reverse administrative agencies' findings if they are not adequately supported by substantial evidence. In Kabalit v. Commission on Audit Region 7, the court emphasized the need for substantial evidence to support the Ombudsman's findings, and interference is only warranted in cases of grave abuse of discretion. The CA in the present case found no substantial evidence supporting the conclusion that respondents were guilty of administrative charges, asserting that mere allegation and speculation do not constitute evidence. Since the CA found the Deputy Ombudsman's findings lacking substantial evidence, the doctrine of conclusiveness does not bind the court to uphold those findings. The CA's appreciation of evidence: no substantial evidence exists to support the latter's decision, as the affidavits upon which said decision was based are hearsay evidence. It found that the affidavits lack the important element of personal knowledge and were not supported by corroborating evidence. Substantial evidence, quantum of proof in administrative cases. Substantial evidence is defined as such amount of relevant evidence which a reasonable mind might accept as adequate to support a conclusion. Section 27 of the Ombudsman Act of 198924 provides that findings of fact by the officer of the Ombudsman, when supported by substantial evidence, are conclusive. Any order, directive, or decision imposing the penalty of public censure or reprimand, suspension of not more than one month's salary, shall be final and unappealable. Their complaint affidavits and the NBI progress report. As correctly found by the CA, these pieces of evidence do not meet the quantum of proof required in administrative cases. Any evidence, whether oral or documentary, is hearsay if its probative value is not based on the personal knowledge of the witness. Not one of the complainants actually witnessed the transfer of money from Alingasa to Erederos and Mendoza. Nowhere in their affidavits did they specifically allege that they saw Alingasa remit the collections to Erederos. There is no specific allegation that they saw or witnessed Erederos or Mendoza receive money. The complainants alleged in the preface of their affidavits that they noticed and witnessed the anomalous act. Mere uncorroborated hearsay or rumor does not constitute substantial evidence. The affidavits also show that the complainants did not allege any specific act of the respondents. The affidavits allege is a description of the allegedly anomalous scheme and the arrangement where